All right, I'm going to go ahead and get started. On behalf of the JCRC of Greater Washington, American Jewish Committee, the American Association of Jewish Lawyers and Jurists, the Jewish Federation of Greater Washington's Next Gen Lawyers and Lawyers Divisions, and SEDEC DC, it's my pleasure to welcome you to this installment of our virtual Brown Bag Lunch series, The Fall of Roe, How Did We Get Here and What Do We Do Next? Next week, the JCRC will be hosting legislators from around the region to discuss local laws and legislation, and we hope you will join us for that as well. Before I introduce today's guest, let me point out a few logistical things. First, today's conversation is being recorded. We have turned on automatic live transcription, which you can activate on your own screen if it's not already showing. And finally, at the end of the opening remarks, we will be taking questions through the chat. Please put your questions there and we will get to as many of them as we can. It's now my pleasure to introduce my dear friend, Helene Krasnoff. After sharing time and space with me in Ann Arbor and a post-bar trek around the country, Helene spent some time as an associate at Arnold & Porter, and then in 2020 moved on to a position with Planned Parenthood Federation of America, where she now is the Vice President for Public Policy, Litigation, and Law Department. She is responsible for challenging attempts to restrict access to reproductive health care, advising Planned Parenthood affiliates about the related legal issues, and assisting with Planned Parenthood's efforts to influence state and federal legislation in order to improve access to reproductive health services. Helene has been involved in dozens of challenges to state laws and policies, including before the U.S. Supreme Court. She has worked with members of Congress on federal legislation and addressed challenges to laws restricting Planned Parenthood's ability to provide family planning services in public programs, denying access to medication abortion, and mandating parental consent for abortions performed on minors. She has also worked with members and staff on Capitol Hill on many pieces of legislation, including the Affordable Care Act. Once Helene is done, Gila Franklin-Siegel will go ahead and lead the conversation, moderating your questions. Gila Franklin-Siegel is the Associate Director of the JCRC. She is an attorney, a graduate of New York University Law School with over 20 years of experience in Jewishly grounded social justice and women's advocacy and empowerment. Helene, take the floor. I think I might have to help you turn on your, there we go.
No, I think I'm good. Yes, thank you. And thanks for having me. And thanks for all the interest. So I think this was like where we are and how did we get here? I think you all know where we are, but just in case, in less than 3 weeks ago, 5 justices on the US Supreme Court, 3 of them appointed by President Trump, those obviously being Justices Gorsuch, Kavanaugh, and Barrett, those 3 being joined by Justices Thomas and Alito, eliminated our constitutional right to abortion that had been established nearly 50 years ago in Roe versus Wade. And it wasn't just Roe, that had been over that 50 years, the court had affirmed and reaffirmed again and again that right. But that precedent was all wiped away. I'm going to say a little more about that opinion. But what has happened in just those 3 weeks is that abortion is now banned in 12 states: Alabama, Arkansas, Florida, Missouri, Mississippi, Ohio, Oklahoma, South Carolina, South Dakota, Tennessee, Texas, and Utah. 7 of those are complete bans on abortion. 3 more are bans at abortion beginning at approximately 6 weeks of pregnancy, before many people know that they're pregnant. And then there's a ban in Florida in effect at 15 weeks and in Utah at 18 weeks. And there are likely more to come soon. So one thing I want to emphasize about sort of how we got here, given the title of this talk, is how sort of little people understood that nothing needed to happen for this to happen after the opinion. There was a misconception, I think, that, Roe would fall and then state legislators would have to come back into session and they'd have to decide whether or not they were going to ban abortion. But those dominoes have been in place, and all that was stopping it was this push from the federal courts. And I want to focus on, I think it's really important that this was a plan, right? It's worth looking at those laws and when they were enacted, so you can sort of really focus in on what really changed everything. Of course, since Roe, and although before I do that, I should step back, right? Since Roe, politicians have never stopped trying to put restrictions on abortion. And Roe was actually, of course, never enough. Even under Roe, far too many people did not actually have access to abortion. They had a right that was not meaningful. The Hyde Amendment denied low-income patients access to abortion, and state laws like that impose burdens and stigmas on seeking abortion, like making patients make 2 trips to a health center and receive state-mandated information in order to access healthcare, already singled out abortion and denied access to too many. So it was never enough, but what it did do is prevent states from banning abortion. 9 states had pre-Roe bans on the books that were never repealed. So those were already sitting there. But the big turning point in this landscape really comes in 2019. So what happens in 2019? There's like a big event for those of you lawyers. In 2019, Justice Kennedy, who had been in the majority in not only Planned Parenthood versus Casey, but just however many years ago now, 3 years ago, in Whole Woman's Health, 6 years ago, Whole Woman's Health. Anyway, in Whole Woman's Health, announces he's going to retire, and he is replaced by Justice Kavanaugh. And in 2019, 10 states enacted new laws banning abortion at some point during pregnancy. Every single one of those was blocked by the federal courts due to 50 years of precedent that says prior to viability, which in a normal pregnancy occurs around 24 weeks of gestation. Prior to pregnancy, a state cannot ban abortion. So all of those 10 laws were blocked by the federal courts, but were sitting in litigation 3 weeks ago with injunctions based only on Roe. One of those is the ban that was upheld in Dobbs, but there were 9 others. That same year in 2019, 9 states enacted trigger bans. Those are laws that don't really exist for other issues, but that said, when and if Roe is overruled, our state bans abortion. It has a trigger. It will take effect then. There were 4 states who had done that earlier, but 9 more passed them in 2019. So that bringing the number of trigger bans in place prior to 3 weeks ago to 13. So that's 10 pre-Roe bans, 13 trigger bans, and 10 bans in active litigation that were all sitting there at the time of what we call Jehu or Dobbs decision. They were only, again, being kept at bay and not being enforced because of Roe. So, these dominoes were there long before the court's decision, long before Alito's leak. All they needed was that push that they got from Justice Alito. And I think, the other thing I will say about how we got here, we should have known this was coming for at least 3 reasons. So one, actually 4 reasons. One, the court took the case in the first place, right? There was no circuit split. In fact, Mississippi didn't even ask the court to overrule Roe when it petitioned in this case. Every single court in every one of those ban cases and earlier ban cases that are closed had said, central tenet of Roe, and those are the words that Chief Justice Roberts used in the June medical case just 2 years before to describe this principle. He said, the central tenet of Roe is that prior to viability, a state cannot ban abortion. And when Mississippi petitioned the court, they said, you can uphold this under Casey. You don't need to overrule Roe. This is just like a ban at 15 weeks, that's fine. But when they petitioned and wrote that, Justice Ginsburg was still alive. And I think, based on the court having just decided the June medical case, they didn't think they had 5 votes. It was only after Justice Ginsburg died and was replaced with Justice Barrett that the court took the case. The court sat on that petition a very long time, and it was only when the personnel changed that the court took the case. And at that point, of course, Mississippi changed its tune and said, no, you should overrule Roe in this case, which of course the court did. The second reason, of course, is Texas. I don't really understand why the court allowed Texas as SB 8, the bounty hunting law that it let take effect last September 1st, why it did that, if it was actually 10 months later going to overrule Roe entirely, but it did. And it's worth noting that in that decision in September, or maybe it was its December ultimate decision, but I believe it was in September when they refused to block the law, they, banning abortion at 6 weeks was blocked by 50 years of precedent. Every court had said that. And the court could only bring itself, those same 5 members who overruled Roe this last month, they said that that was a substantial question in the Texas case. Not that the Texas law was unconstitutional, but there was a substantial question about whether or not a 6-week ban was unconstitutional. 3, the oral arguments in December. They were kind of nothing short of shocking, really. And I do think those can't predict the results. I actually think most of the commentary after the oral arguments in the Texas SB 8 case suggested the court would actually block SB 8, which it did not. So oral arguments are not predictive. But in this case, everyone wrote pretty much the opinion in Dobbs that they seemed like they were going to write from the bench. And fourth, of course, is the leak. And what we got from the court was basically almost identical to the leak. So in some ways, of course, the dominoes have been there. We have known that for a very long time. And there were lots of reasons that we knew before 3 weeks ago that there was likely to be that push from the Supreme Court. So I'm going to talk a little bit about the decision. I'm sure most of you know this. I'm just going to say a little bit about the majority opinion authored by Justice Alito. It relies largely on what has been called originalism. The analysis is mostly the word abortion is not in the Constitution. And then the court asks if this right is deeply rooted in our nation's understanding of ordered liberty. And the court finds, of course, it cannot be deeply rooted because when the 14th Amendment was adopted in 1868, most states didn't allow abortion. There's been a lot written after the leak about the history and what Alito got right and what he got wrong and what was really the law. Actually, to me, that misses the mark. Obviously, why should 1868 be the touchstone for our liberties, regardless of what was going on then with respect to abortion? We know that so many of us were not free, let alone equal, in 1868, and to freeze our rights there is no concept of liberty, let alone one that we can call ordered. And, of course, although all these justices told the Senate that these cases were settled law, I believe Kavanaugh said precedent on precedent, whatever that means, never really meant anything then, obviously. The whole analysis of whether they should erase 50 years of law really begins and ends with their decision that Roe and Casey were egregiously wrong. They don't really engage in any real stare decisis analysis. And I'm going to give a few of the quotes from the dissent because they can say it better than I can. I should note that it was a joint dissent. Justices Breyer, Sotomayor, and Kagan wrote together. That is pretty rare. And I think that says, it's actually not, I didn't even think that could happen. I didn't even realize when I first read the opinion that is what had happened on that day. But anyway, now I'm quite aware it's a joint dissent. But on stare decisis, they say, quote, the majority has overruled Roe and Casey for one and only one reason, because it has always despised them and now it has the votes to discard them. The majority thereby substitutes a rule by judges for the rule of law. And what I personally find perhaps most upsetting about the majority opinion, having literally grown up under Roe, is how they ignore both the role abortion has on people's lives over the past 40 years and what taking that right away will mean for families all over the country. And of course, the dissent also says it better. They say, quote, after today, young women will come of age with fewer rights than their mothers and grandmothers had. The majority accomplishes that result without so much as considering how women have relied on the right to choose or what it means to take away that right. The majority's refusal even to consider the life-altering consequences of reversing Roe and Casey is a stunning indictment of its decision. One more note about the dissent. The usual conclusion for a Supreme Court dissent is to say, respectfully, I dissent. And in this current environment in the court, that has changed some. In some cases, they've sort of just dissented, just said, I dissent. They've taken away the respectfully. But these dissenters actually went even further and concluded their opinion with sorrow for this court, but more for the many millions of American women who have today lost a fundamental constitutional protection. We dissent. So that's the 5 in the majority. That's the 3 dissenters. So that leaves Chief Justice Roberts out in the cold. He did not join the majority opinion, but I want to be clear about that. He did not actually say that he thinks Roe and Casey were not rightly decided, and he did not say that he would not overrule them. What he said is that he didn't need to decide that because he was happy to overrule just part of Roe, not all of it. The part that, as I mentioned, he had called its central tenet 2 years ago. So he was basically fine that Mississippi could ban abortion at 15 weeks, more than 2 months prior to viability. He just didn't think the court needed to go all the way and say Roe is not, the court wasn't really being asked, he thought, like Mississippi came to them in the first place. He was holding Mississippi to their original word that they didn't need to overrule Roe to decide this case. But of course, it's worth noting that he was a man on an island with the 3 Trump nominees. They just did not need him. So what happens now? We are fighting back along with our coalition partners at the ACLU and the Center for Reproductive Rights. Just in the past 3 weeks, there are now 13 cases in active litigation in state court that challenge abortion bans. There are challenges in Florida, Idaho, Kentucky, Louisiana, Michigan, Mississippi, North Dakota, Ohio, Oklahoma, Texas, Utah, Wisconsin, and West Virginia. Those advocates separately and together have brought 12 of those 13. In Wisconsin, the case was brought by the governor and the attorney general. Planned Parenthood affiliates are part of 7 of those 13 cases. In 4 of those cases, Kentucky, Louisiana, Michigan, and Utah, there are now injunctions blocking those laws and access to abortion remains. Idaho and North Dakota's triggers, which are challenged, have not yet taken effect, although the challenge has been filed. So there's still abortion access in those states also. For those of you who are not lawyers, each state has its own constitution that is separate and apart from the federal constitution. Sometimes they are quite similar. Sometimes they are quite different. Sometimes even when they are similar, the state courts have the ability to and have interpreted them broader and differently from the federal constitution. So these challenges, for the most part, say that the ban in question violates state law and or the state constitution under different provisions, and they vary state to state in terms of the claims. Suing in state court under state constitutions, I think this was another misconception pre-Dobbs, is that is not actually new. In fact, many state courts have found that their constitution independently protects the right to abortion, and in many cases separate and apart from any federal right that was under Roe. So these new cases sort of ask these courts to say that when they have not already. And if those courts agree, then abortion would remain available in those states. But I want to, it's going to be state by state. Many of these states with bans are not probably super friendly to access to abortion. A number of these judges, of course, are elected. And so it's certainly not going to be the same as having had a constitutional right which protected at least some access and protected us from bans for 49 years. So as bad as this is, I actually think we haven't kind of reached the bottom yet for at least 3 other reasons that I want to sort of leave you with. So 1, we know that our opposition is not going to be satisfied with banning abortion in certain states. They are already making clear they're going to try and stop residents of those states from accessing abortion. I want to be clear, this is not how we understand our laws. You do not take the law of your state on your back when you travel somewhere else. It's not how we understood it pre-Roe, that everyone said women could travel to New York or California. No one tells you that if you live in Utah and Utah doesn't allow gambling, you're not allowed to go to Las Vegas and go to the casinos. It's not how pot laws work. And if any of you are old enough to remember, it's not how the drinking ages worked either. Back in the day when states had different drinking ages, if you lived in a state that had a drinking age of 21 and you went to one with 18, they looked at your ID and said, you're 18, that's fine. But that is not what we're seeing from our opposition. Our opposition is trying to not only say, Texas, you live in Texas, you can't help anyone leave Texas, you can't provide abortions to people from Texas. This has not happened. This is not the law now, but we are seeing people saying that this is what they want the law to be. That has significant legal problems. Again, it's not how we understand the law. It has Commerce Clause problems. It has travel problems. Attorney General Garland has highlighted some of that in his remarks, and it's something the Justice Department task force that they announced yesterday said they're going to look at. But just to be clear, Justice Kavanaugh claimed this like neutrality. It was just going back to the states. They was going to put an end to this debate. And he tried to actually say states can't do this in this. He said he thinks that barring someone from traveling would be too much, but he was one person who said that. And already we are seeing Texas politicians threatening that they're going to come back and do this anyway. So the idea that this is sort of over when it goes back to the states, I think, no one ever really sort of believed that. The second reason, we sort of haven't reached what could be the bottom, is that our opposition has been very open that the ultimate goal is a national abortion ban. I guess the day of the opinion or after the opinion, Senator McConnell was honest and said that, although I think he may have walked that back. So I think I want to be, I think it's important when we have these discussions to realize that, living in New York or living in Maryland like I do, is not going to save you from a national ban. And in his concurrence, when he talks about, the Kavanaugh, when he talks about how this is just the Supreme Court being neutral and leaving it to the democratic process, it's actually not back to the states, is what he says. Unlike where he says, I think you can't stop people from traveling, he doesn't say that here. What he says is that he's leaving it to the states and Congress to decide. And the dissenters picked up on this too. They said, quote, most threatening of all, no language in today's decision stops the federal government from prohibiting abortions nationwide, once again, from the moment of conception and without exceptions for rape or incest. If that happens, and they quote Kavanaugh, the views of an individual state's citizens will not matter. The challenge for a woman will be to finance a trip not to New York or California, but to Toronto. And then the third final sort of bad news before we open it up to discussion, I wanted to say is I do think it's worth noting that, Justice Thomas, as you all probably know, said the quiet part out loud. And he wrote separately to say that he thinks the court should revisit the entire doctrine of substantive due process and overrule cases about access to contraception, about consensual sex between same-sex individuals, and about marriage equality. And of course, that is intellectually honest of him, because those actually are all part of the same liberty right that our right to choose was part of until 3 weeks ago. And the dissenters warned about this too. Quote, no one should be confident that this majority is done with its work. The right Roe and Casey recognized does not stand alone. Either the mass of the majority's opinion is hypocrisy or additional constitutional rights are under threat. It is one or the other. So, there's no sort of alarm I could sort of sound louder than what I am doing here. It affects every single one of us, regardless of where we live. And, even in just 3 weeks, unfortunately, for far too many, the impact and the harm are sort of already here and will continue, with each passing day, really, at this point.
Thank you so much, Helene, for that really compelling and organized summary of what is a very complex issue that is going to have very complex ramifications. And I want to thank you for your dedication and devotion, professional devotion to this area of work, which goes to the heart of how so many people view themselves as Americans and as human beings. So thank you. Obviously, this decision has really struck a chord of fear and anger and concern in the Jewish community. Access to abortion and reproductive rights is one of the issues that the Jewish community in the United States is the most unified on. Most recent polls show that 82 to 83% of American Jews support access to reproductive rights. And a piece of that is rooted in our own religious tradition. Abortion is not banned under Jewish law. In fact, even under the most strict interpretation of Jewish law, it is required in instances when the mother's life or health is in danger. The mother takes priority. And Judaism also does not believe that life begins at conception. Given all of that, the big discussion has been about using the First Amendment and religious liberty arguments to challenge bans on abortion. And so I wanted to ask you whether you think that line of argument has viability, given the discussion of the peyote case, the Smith case by the Supreme Court, given the fact that there are many states that have their own codified Religious Freedom Restoration Act statutes that protect religious liberty rights within their states. How do you see that playing out?
Yeah, you said the RFRAs, but they also have state constitutional provisions as well. And actually our challenge in Utah does bring a challenge under the religious liberty clause of this sort of claim in our new Utah challenge to Utah's trigger ban. You probably have also heard that there's a rabbi in Florida who brought a separate challenge in state court in Florida. He actually calls himself the Rabbi Rouser, apparently, to Florida's 15-week abortion ban. I think that case hasn't progressed very much, but I think it is certainly, in some, I mean, I know what Utah responded in their brief to that argument, but we do have a preliminary injunction in Utah. It is not, the court didn't rule on each claim and say why he granted the preliminary injunction. I think that we relied on the substantive due process right that we had for 50 years in our cases, because that was black letter law. As you can see, it kept every single ban at bay. But we are in a very new world. And so I do think that we need to hold officials at every level of government and every branch of government accountable for the decisions they are making and how that impacts people and where people agree and don't agree with them. And so I think every argument can and should be on the table. Do I think that the majority of the US Supreme Court, when they talk endlessly about religious liberty, this is what they have in mind? I'm not going to speculate about that. Maybe they do, but I think that I think that every argument about how this impacts people and their lives and their beliefs should be made, because we are in a very different situation than we were when we had a federal constitutional right that protected us. And so you could have maybe then said, well, this argument this, that argument that, and so we didn't see it that much. But I think now, and again, in state court in particular, some states have been interpreting their own provisions and their own laws differently from the federal too for years. And so I think that would be great to explore all of that.
One more question, and then I'll throw it out for questions from our participants. I was very struck this weekend by a formal letter sent by the Freedom Caucus in the Texas state legislature to Sidley and Austin. Like thousands of other employers around the country, including a ton of law firms, Sidley informed its employees that it would be covering the cost of transportation and accommodations, whatever is required for employees and dependents to access reproductive health care outside the state. Sidley was unceremoniously informed that there were a significant number of legislators who consider that complicit with murder, which is against Texas law, they called it murder of the unborn. So there are all these, I consider that in the family of all these really proactive, well-meaning steps that are being taken to try to protect access to reproductive rights, including transporting people, everything as you were saying. Do you think that there's going to be this liability? The letter said each and every one of your partners could be subject to criminal prosecution.
I think they sent the letter to all of the partners. It says CC all attorneys, really? Or maybe all partners at Sidley and Austin, which I actually didn't realize on Friday. Someone told me that Monday, perhaps, and I was like, they what?
Yeah, that was my reaction. So if you could talk a little bit about that, that would be great.
I think that's sort of what I was saying too, in terms of, the bottom hasn't fallen. It is not the first action that folks in Texas have taken against what I would call the helpers. They had already said something. I think Citigroup had said something about SB 8, although maybe that's wrong. It's a different financial institution. And the same legislators had already said something about that. Again, I think there's two things. I think that they're trying to manipulate current law to say that that you can't help people. And like I said, I think that is just not how we understand our laws. And there are significant legal problems with it. And then on top of that, they are saying they're going to pass laws that do that, I think perhaps recognizing that they don't do that now, or that they have significant legal problems. So I want to sort of help tease that out. But I also just want to talk about the crisis that we're in when employers and corporations are making these decisions. So 26 million, 26 states. So we are already at, what did I say, 13 today, but 26 states are poised to ban abortion, and 36 million women live in those states. And so we're not talking about a few people. We are talking about hundreds of thousands of abortions that are performed every year, for which people will need to travel. And those people need help. They're not all going to be able to get help no matter what we all do. I should put a plug in here. If you're not familiar with the abortion funds, you should get familiar with them. These are organizations that are devoted to helping. They are mostly local grassroots organizations that have networks to help provide transportation and funding. They are a lifeline at this moment, and they have been doing this work for years already because access was so poor. There's a national, it's called NNAF, the National Association of them. So if your locality or even your donations and getting involved, the abortion funds are more important than ever. But I think this is, to come these battles, like I said, the idea that this was going to end it all was, I think, what did they say, is either hypocrisy or something else. No one ever really believed that was going to happen. Missouri had passed a bill last year that said like an SB 8, not passed, had said they wanted to pass. They had introduced a bill like SB 8 last year that said you could sue anyone who helped anyone from Missouri get an abortion. And so we knew this was coming. I think that the question is, the choice for, literally all of us, because now I guess they're threatening lawyers in New York or whatever, is, in this circumstance, whether to leave 36 million women with no help or to help them and fight about it. And so, again, I think, I would like to think this is an overplay of their hand. But, I think that I haven't seen anything from Sidley, but I have no indication that they've told their staff, oh yeah, we're not going to help you.
Right.
Thankfully. But so, I think this is, like I said, one of the ways in which we haven't reached their ultimate goals, which is a national ban.
Right. And I just want to reiterate, we are doing a webinar next week with the DC Abortion Fund, which covers all of our 3 jurisdictions in the greater Washington, DC area, as well as with legislators from each of the jurisdictions to discuss that. So yes, very, very important. I'm going to go. There are lots of questions in the chat, as I'm sure you can imagine. So I'm just going to go through some of them. This question is from Harvey Ryder, our colleague. Alito's decision says Roe was being reversed because it was egregiously wrong from the start. What do you think this means in general for the principle of stare decisis? It seems like a new standard. The Federal Baseball Association versus Baltimore Baseball Club held in 1922 that professional baseball was not commerce, so the antitrust laws didn't apply to it. That case was egregiously wrong from the start. Babe Ruth was hitting home runs before packed crowds in 1922. The court unanimously said in 1970 that this ruling was ridiculous, but applied it under stare decisis principles to deny Curt Flood the ability to change employers. Any hope that the court might give greater weight to reliance interests under stare decisis if challenges are made to the right to birth control or same-sex marriage?
Either it's hypocrisy or they're lying. I don't know that, I don't know. There is no, I don't know. Thomas wrote alone, and they tried to say that somehow abortion was different. They did not do that on reliance interests. They did that on ordered liberty, that basically because there involves a fetus, it can't be ordered liberty. That's a bit of a summary, but that's kind of how I read the decision. And so I think what they were trying to say is that it is not. But, if your test it was really only a 2-part test, right? It was, is it in the text? So we know that's not true for any of the substantive due process rights. And the notion of ordered, was it deeply rooted in the notion of ordered liberty. So that's a question. They will 5 justices say that those other rights are deeply rooted in the notion of ordered liberty, whereas the right to abortion is not. I think that's the analysis. I think that's the substantive analysis. Then there's a stare decisis analysis, which again here was just egregiously wrong, you know, and the reliance interests were so dismissed as if, I think they said it's not like a traditional reliance interest because basically people who have unplanned pregnancies like don't have them. This is even wrong because the opinion like took effect immediately, but don't have them today. So like the people who need the abortions a year from now, it can't be in their reliance because they don't even know that they're going to need them. But of course that dismisses like that for 50 years, women have planned their lives, their careers, their families, their education, everything about the way they existed in the world, knowing that this was something that was there for them should they have an unplanned pregnancy. And so Justice Alito dismisses that to the democratic process and says basically like, did you know women can vote and they can even hold office? So there's that.
Right.
And so something that Gila said though too about the sort of polling within the Jewish community, that is not unique. Banning abortion is not popular in any state, and 80% of Americans did not want to see Roe versus Wade overruled. You know, the court is in theory, counter-majoritarian institution for reasons, but our other institutions that are supposed to be majoritarian are not working for other reasons separate. And I do think separate from the legal questions that you're raising in this question, there are other questions about that sort of where we are in the democratic process about whether or not we are seeing the results of what the majority of people want. I mean, again, when the court just says we're going back to the democratic process, they don't raise any of that.
Right. Another question. Could you explain how the bounty hunter law passes muster? In other words, how can an individual have action with respect to another unrelated person choosing to have an abortion?
So we actually
I don't have a right to sue my neighbor if they choose to break the law in some way. I don't understand how these laws work.
So we have a challenge in Texas state court separate from the federal court challenge that the Supreme Court rejected to this question of standing, right? I think what you're asking, if you're not injured by this person, it's really a question of whether Texas can enact a statute under Texas law and create and give standing to an uninjured person. And that case is theoretically still working its way through the state courts in Texas, although I believe given that the pre-Roe ban has been put into effect by the Texas Supreme Court, and 30 or 60 or something days after the ruling, the trigger complete ban will be put into effect. The Texas Supreme Court may never answer that question. There's also challenges to SB 8 style laws in Oklahoma and Idaho that are in both of those Supreme Courts as well. So maybe they will answer that question, but those cases raise this very question, which is, you know, basically, can the legislature confer standing on uninjured individuals by means of statute, the sort of bounty hunting?
Another question that I think is particularly important on the minds of the Jewish community, Jewish women experience higher rates of infertility than the general population, and therefore utilize fertility treatments at higher rates. So the question is, can you please speak to the impact of the concept of life beginning at conception and what potential impact there could be on IUDs, Plan B, IVF, IUI, and the like, and surrogacy, but also.
No, all of it. I mean, and I think, all of that I think is arguably in play. And I think on top of that, I think miscarriage too, right? So there is no way to distinguish between a patient who's taken medication abortion pills and a patient having a miscarriage. And there is no way to investigate that without policing their pregnancy, right? Like, this is a question, and we've already seen this. We've seen, reports that pharmacists are denying access to medications that could be used in medication abortion for other purposes. I think in Louisiana, a pharmacist denied a woman methotrexate, which is used to treat lupus, because it also can be an abortifacient. I could have gotten the state wrong but there's been a lot of incidents already reported. We saw some reporting out of Missouri that said that some people thought that Plan B and other contraceptives were banned, and they are not. You can get contraceptives in Missouri, but this is certainly, not only are these things could be true under the black letter of the law, more importantly, there is no way to, people are, to the Helene Austin point, which Helene Austin, as far as we know, is not backing off. People are, scared. These are criminal laws, criminal prosecution. There are a lot of lawyers out there that take very conservative positions when faced with criminal penalties, understandably. And so we are seeing all kinds of stories of people backing off on any kind of help for people far beyond just abortion, even just these like life exceptions in hospitals. Like, what kind of committee has to decide when you are sick enough that you can have an abortion, right? Like, some hospitals I'm sure will be great and brave, and lots of them will not, in lots of small communities. And so this is going to be disastrous for reproductive health care of all kinds. And we are already seeing some of that reporting coming out, and there will just, I'm sure, be more of it.
Right. I was just going to ask you about that, because I had read about emergency room doctors who are refusing to treat incomplete miscarriages and sending women 12, 14 hours away to receive care, which I presume could be very life-threatening. When I had
HHS put out a bulletin this week, Secretary Becerra did, on this under EMTALA, the Emergency Medical Active Labor, can't get all the order of the EMATLA, Active Labor Act, reminding all hospitals that accept Medicare that they have an obligation to stabilize and treat pregnant patients, including in these circumstances, and that there's a complaint process everyone should be aware of. If I think that the goal would be to make hospital counsel err on the other side of a complaint that would take away their Medicare money over the other way around, the fear of prosecution. But I definitely think that even just having to make that decision is terrible, because that's going to take time when someone needs treatment. And again, the laws have all these adjectives: serious and irreversible impairment of a major bodily function. So you're going to have a bunch of lawyers in the hospital arguing about whether or not it meets that standard before you're going to be able to provide treatment.
In real time, yes, exactly. When every minute matters. When I had a miscarriage, my discharge papers said abortion. It's the same treatment. So, and I find it hard to believe that there won't be women whose lives are not imperiled or, God forbid, lost in that critical decision moment. Okay, moving on. Well, you may not be able to answer this, but what are the chances that the suits you are filing will succeed? And what are the chances that a federal abortion ban will succeed, which you talked about, with a proviso for rape and incest, with a proviso for rape and incest, and without such provisos? If the federal government were to enact a law upholding abortion rights, what are the chances that SCOTUS would strike it down? And also, adding to that, could there be a ping pong effect where every time control of Congress shifts to a different party, the state of the law were to change?
I think those are all really good unknown questions. I expect if, Congress, the House had already passed the Women's Health Protection Act prior to this. It does not have 60 votes in the Senate and does not have 50 votes committed to changing the filibuster for it at this moment in time. I am sure if it were enacted, it would be challenged in the federal courts for many reasons, and who knows what the federal courts would do with that. I think that is, likely the same on a national ban. Although, again, as the dissenters point out, there's nothing in this opinion that says that they would have a problem with a national ban, and Kavanaugh suggests to the contrary. In the state court cases, like I said, there are a lot of state courts, and they're not, who you always think of, Montana, Alaska, Kansas, who have found a right to abortion in their state constitutions independent from the federal constitution. So I also think that asking judges to find a right when there was also a federal right versus finding a right now that their decision is what is between whether or not pregnant patients will live or die, is different. And so, I am optimistic that there will be some relief, but again, it's not going to be, I don't think that, every judge in Mississippi, Louisiana, I don't know which states, but, it's going to find that way, and it's going to be a patchwork. And there's going to be a lot of people who, had a right for 49 years who now have to travel out of state. It's going to be millions of people. Even if we win a lot of those state cases, it's still going to be millions of people. And then to be clear, when that happens in Kansas, it's now on the ballot to change their constitution for a constitutional amendment so that the Constitution will not be interpreted the way that it was. And so we will see, I think, ballot initiatives as well on both sides. I think that, there's signatures being collected in Michigan for a ballot initiative to support access to abortion. And so I think this is going to be in state legislatures. It's going to be on the ballot. It's going to be in the courts. And so it's going to be a state by state fight now. And I encourage everyone, to get as involved as they can, because there's not a backstop that there has been for the past 50 years in all these,
Right. And are there ways for individual attorneys to get involved?
That's really good.
Ask that in the chat.
That's a really good question. So right now there's well, you can definitely offer your services to, if you're not DC based, which I think you all are, to like your local communities, if you have any expertise, or if you're barred in Arkansas, I definitely think that the providers, the independent providers and the funds in the, that don't have the outpouring of blue state support, can always use help. But there's at least two initiatives. There's an initiative that Tish James is leading out of New York that is along with some firms that are, I think maybe Paul Weiss is coordinating. And there's a similar effort out of San Francisco, the city attorney, and I think that someone in an Arnold Porter San Francisco office is leading it. And the San Francisco one, I think, has at least 57 law firms signed up for support to help provide legal advice and support and potentially legal defense, because these laws are all criminal, and we will be seeing prosecutions of providers as well as patients, as this unfolds, I'm certain, as the Texas folks have threatened Sidley and Austin. And so I think that firms, through those initiatives, I know those initiatives are going to try and do some like webinars and trainings, and try and get people a little more expertise before they send them off into this world of the law. But there certainly are, these groups forming.
So, and we will do our homework on our end before our webinar next week to be able to share that information with our local community. Another question, are the abortion funds tax exempt? Has anyone considered that 501c3s can't support actions that are contrary to law? And that the IRS would be the one to tell the states that their laws are unconstitutional. Recently, the IRS refused to give exemption to organizations that are just business leagues that are C6, not C3, when they supported the marijuana industry, which is still illegal under federal law.
So the funds are nonprofit organizations, but there's, to be clear, the sort of threats that we've talked about are not law. There is no law barring anyone from helping anyone at this moment in time access abortion from one state to another. They have not been enacted, and as far as I am aware, there are no funds helping anyone violate the law. In terms of, providers have always been, abortion has always been a highly regulated space, to say the least, for the past 50 years, and the abortion providers comply with those laws, and I believe they are today as well as the funds in terms of helping them.
Is there a central location online that one can monitor to stay abreast of all the moving pieces and to identify areas where individuals can access abortion and can give up? Is there one central or easy place where all this information is being aggregated in real time?
So there's a website that is We're directing people to Abortion Finder, which is a power to decide site, which is how patients are navigating where appointments are available and which providers are offering what services, right? And it's changing so fast in real time, right? Like last, I don't know what, Friday at 4 o'clock, the Tennessee 6-week ban went into effect, and that all has to be changed at that point in time, you know. But that's where we've been directing patients who have concerns. In terms of like the sort of like law and advocacy stuff, I think the Lawyers Alliance in San Francisco, which is not yet up and running, but is hoping to be, I think, a bit of a clearinghouse. And then, you know, the government started a reproductiverights.gov, although the information on there right now is pretty basic, but we're hoping that that will get, you know, as time gets going, that will get, and I think they link to Abortion Finder as well. As time gets going, they will have more robust information on the government website as well.
Okay, great. I'm just looking through all of these wonderful questions. Let me see, because we've combined a lot of them. Do states have equivalents to the Federal Bank Secrecy Act? And could that and their state counterparts be used against abortion funds?
I need that person to explain that to me because I don't know what that is.
Okay, I would be happy to unmute, or Vicky can unmute for the person who asked the question. Jason Loss, if you can.
Yep, I'm looking for Jason. Why don't you go ahead and go on to the next question while I try to unmute Jason.
Okay, next question. What about clergy, rabbis who offer counsel to provide abortion and provide their their assessment of Jewish law? Are they safe from criminal charges? My rabbi supported us when we had miscarriage and to not proceed with the pregnancy when my life was at risk.
I mean, I think this is, again, the Missouri proposed law last year said you could file a minimum bounty lawsuit like Texas FDA against anybody who helped anybody, aided and abetted anybody getting a Missouri resident getting an abortion outside of Missouri. That did not become law. Again, that is not the law. That is not the law today. If that were to become the law, and if that were to be upheld by the courts, there would be a question about what aiding and abetting means in that circumstance, right? To be clear, there's First Amendment rights to speech as well. So some of what you're talking about is just speech, right? I don't know where there's a question of when conduct has some First Amendment protection as well. And so I think there are significant legal problems with trying to do these things, and they are not the law today. And I think this question of, fear of the sort of parade of horribles to not be a helper in this situation is troubling, and that, we want everyone should make their own decision. But, again, I just want to reiterate that there are already these 12 or 13 states where patients have to travel. There will be more. And again, 36 million women of reproductive age live in those 26 states. This is not like something happening in one place with a few people. And so I think there's just a lot of unknowns, right? Again, this is not, and no one ever said this. Like, if you just think about the gambling again, right? Like, nobody has ever said this. Nobody has said, if you tell somebody that gambling is legal in Las Vegas, you're going to get a $10,000 lawsuit against you, or that, you're going to go to jail. Like, this is not, this is a kind of very skewed view of the law that is purposeful. It is purposeful to create fear and to isolate millions of people who are trying to access healthcare that like 1 in 5 women in America will seek in their lifetime. And so, my personal view is that, we should be helpers in that circumstance.
Right. Has there ever been another instance where the Supreme Court took away a right that had been previously granted? I know that they compared it to Plessy versus Ferguson, but that was the exact opposite. That was a case that refused to grant a right being overturned in favor of giving the right. Has there ever been this scenario before?
I mean, I think the answer is I'm not a full constitutional like historian or scholar in a way that I can actually. There's been a lot of talk about this question, and I think it's how you understand the word right, like you were just saying, right, and how you answer it. And again, of course, it doesn't really matter on some level, right? What we know is that most people on this call ordered their life around a liberty interest that many of us believe is fundamental to how we, again, went to school, developed our careers, lived our lives, and that was taken away. And I think that, but like I said, I think a part of how, and the writing was on the wall for a really long time, which is what I kind of wanted to sort of like get across also. And, it's going to take a long time to fix it. And so I think that's what we should, focus on as much as we can.
Okay. Vicky.
I think, yeah, Jason Loss should be unmuted, and he also put in the chat that it's the federal anti-money laundering statute that he was referring to. But Jason, are you unmuted?
Yes, hopefully you can hear me.
Yep.
Yeah, as I referenced. So yeah, like if abortion becomes like a crime, right? Wouldn't financing abortion then, enter into that gray, dark world, where like drug traffickers and terrorists and those people are in. And also there's all kinds of like reporting requirements and stuff under the Bank Secrecy Act, especially if you're dealing with large transactions worth of money. Like could that be used? Could some of those provisions then be used, especially if people want to disguise, the source of the funds, to pay for abortions, right? Or am I just like in some very weird dystopian nightmare because I know too much about these things?
Well, I think I think there's a question here about like lawful and unlawful abortion, right? And what is like, I think the premise of our thinking of what is happening in this world, and this is obviously Planned Parenthood is following all laws and is providing abortion where it is lawful and is not providing it where it is lawful, and helping patients access abortion where it is lawful. So I don't think there is an analogy there because there's nothing unlawful happening. I think there's a question of this other question of will other things and the other help someday become criminal? I think that's what a lot of these questions have gone to. It is not. That would change potentially the legal landscape, but if for the many time, I don't think that, I think it has other legal problems too, again, that's not our understanding of how the law works or has worked. And so will people be doing what you are suggesting and providing abortion outside of the law? I think, yes, that may very well happen as well. And that may lead to a different legal issues, but they already have the criminal prohibitions that would be a problem in those states on top of any law like you're analyzing. But, I'm actually, a little too young to remember pre-Roe, but there will be people who operate outside of the legal system and they will have many mechanisms to go after those people. But, the regulated abortion community like Planned Parenthood will be providing abortion in accordance with law. And so then I think it wouldn't trigger any of those type laws.
Next question. If abortion is criminal in a state and a patient, client, or congregant speaks to someone in a privileged relationship, their attorney, their rabbi, their doctor, about their intention to have an abortion, won't that rabbi, therapist, or lawyer have a duty to report in states where abortion is banned?
I think that would be that's, I guess, a question of, I thought you were actually going to go to, could those communications come out under some sort of like exception to a privilege? I think it would depend on the contour of the state law, right? They don't all say, they wouldn't be, again, talking about the commission of crime. They're not going to get an abortion in the banned state. They're talking to them about how to get an abortion in New York where it's lawful. They're talking about lawful conduct. So I do think this is like a conflation that is kind of important, actually, right? Like we are now in a world in which, again, we are providing lawful abortion and helping people access lawful abortion. So there would be nothing to report because there would be no criminal activity. Again, do I think that everybody can't travel? We're talking about, again, hundreds of thousands of people. And so will things be happening outside of the legal system? I am sure they will. There are going to be a lot of people who are very desperate and are going to turn to things that are not lawful for sure. And so those, I guess, in theory could raise some of these questions, but again, they are going to have other potential legal problems as well. But, you know, most of what we are talking about, we're talking about what happens when you go to Abortion Finder, what happens if you come to a Planned Parenthood, what happens if you call a fund, is that they are helping you access legal abortion.
We have time for just a couple more questions. One other question, I don't know if Planned Parenthood has a position on this. The question was, shouldn't we now be advocating for additional justices to be added to the Supreme Court, as because that has been on the table for this reason?
I think that there's a number of groups and a number of court reform proposals that include term limits, they include additional justices, they include ethics reforms, which are relevant potentially for other things in the news. And there are lots of groups that have proposals. There are a lot of bills in Congress. I am not certain which of those our organization has signed on to or not. There's also additional, expansion of the lower courts, which need expansion as well. And so that is certainly, an issue. Biden put together a commission on this. This is another issue on which I don't think that right now there are either 60 votes in the Senate or 50 votes to end the filibuster to change at this moment. But, I think there are, like I said, issues in all levels of government about why 80% of the country doesn't want Roe v. Wade to be overturned. And yet here we are with all these abortion bans.
Here we are, yes. All right. I think we've covered all the questions. I'm going to give everybody one last opportunity. So while I'm giving that opportunity, what has the Planned Parenthood actually closed clinics and stopped providing all services in states where there's a ban in effect now? Because Planned Parenthood provides so many critical health services outside of abortion.
Yeah, no, I'm not aware. I mean, it's only been 3 weeks, and there are different service changes that happen all the time for lots of reasons, but I am not aware that even in states where the Planned Parenthoods are no longer providing abortion, that there have been health center closures. And of course, yes, they're open for all other healthcare services.
Question just came in about the apps that I mentioned before, period tracker apps, those kinds of apps, and the enforcement implications. Kind of now you're talking really dystopian and Big Brother, but I know women are being told to delete those apps from their phones. Can you talk a little bit about that?
Yeah, I'm not a data privacy expert, and I suspect that there are people on the phone who actually are more than I am. I think that, I know that this is an issue. I know that conversations are happening. I know this is another area of the administration. And I believe the task force announcement yesterday, I'd have to go back to it. The DOJ task force announcement includes this issue as well as the interstate travel issue. I think this is something that, and here's my rudimentary understanding. There's many apps that do not collect data and that are sort of safe to use, and yet they still have some data that is available. I think this is like a little bit of I don't understand enough to know, to advise what should or should not be used. I do not think that, I think this is an area people need to think about. I also think that there is privacy law, again, and this is yet another area of law that will be developed over time as we see what this world looks like, where a dozen or 24 states have criminalized medical care.
Right. And this may be a good place, the last question. This isn't a legal question, but presumably Republican women also need abortions. How is there not going to be a political backlash to this in the November election?
I mean, that's way outside of my job description. But like I said, I think we've said there is not a single state where polling has been done. I wish I could find the polling easily. There was recently a poll released about South Carolina, who's one of the states that's coming into a special session. So South Carolina has a 6-week ban that's in effect now, but in theory, the governor has called for a special session, I think, to fully ban abortion. And the polling, I wish I had it, but you can probably just look it up. I think we had a press release I saw go out on it. you know, even the polling in South Carolina, it is unpopular in every state to ban abortion. In 2006 and 2008, I think South Dakota put banning abortion on its ballot, and it actually lost both times. And so, you know, I think, I don't know the answer to how this will obviously affect, you know, the November election. I don't know the answer to that, but, you know, I do believe there was despite the sort of history I laid out and where we were, I do believe there was a believability problem that this was actually going to happen. And so, you know, maybe there will be some change now that people believe it is in fact happening.
Right.
And like I said, I think it's really important for your networks to understand, you know, sort of my closing points. You know, and one of them, obviously, we've talked about a lot, that they don't want to just ban abortion. They want to, you know, sort of lock these people in their states, but also the national ban, right? I think that a lot of our networks live in the sort of either for the most part, a lot of people that on this call probably know live in fairly safe bubbles. And to be clear that this is already happening today in so many places and will keep happening, but the ultimate goal is a national ban. And there is no protection from that, from your own politicians in your state.
Right.
If that is enacted or upheld.
Right. And so that's why engagement in the political process is so key. One last question that came in was the impact of Dobbs on pregnant individuals with disabilities, and that there has not been a lot of discussion of that. For example, even a 6-week abortion ban was pretty untenable, can be untenable for people with disabilities who can't, in that 6-week, may not even know that they're pregnant.
Yeah.
So are there disability rights organizations that are engaged in this work? And really, is that this aspect of this issue being amplified?
I am not sure about amplification. There are certainly, you know, coalitions in which disability rights groups absolutely participate. And to be clear, like, all of these bans fall hardest on those who already struggle to access care enough, right? Like, accessing medical care for the disabled is incredibly difficult. It is for low income patients. It is for, you know, systemic racism for Black and Latino patients as well. And so people who live in rural communities don't have access, and those are the ones going to the hospitals we talked about who are going to see these patients. And so I think there are systemic healthcare problems for these populations, and that is whom asking to travel potentially not just hundreds but thousands of miles to access abortion is going to impact them so much more as well.
Right. Right. Let's see. Yes, and there was a request for JCRC to send out more information on ways to be active, and we will absolutely be doing that. We are at our closing time. Helene, I want to thank you for sharing your expertise with us. This is such an important conversation and a difficult conversation. Wish we weren't here, but we are. And I want to remind everyone that next week we are doing a webinar with representatives from the DC Abortion Fund and with legislators from the Maryland General Assembly, Ariana Kelly, Brianne Nadeau from the DC Council, and Eileen Fillercorn, former Speaker of the House in Virginia, to talk about the state aspect of this. I also want to remind everyone the next Brown Bag Lawyers Lunch will be on July 28th later this month on a different topic with Aliza Lewin from the Brandeis Center talking about the Ben & Jerry's recent developments in the Ben & Jerry's boycott of Israel and the legal win and how it's being challenged once again. So please look in your email for information, or go to the JCRC website or Facebook page. If you're not signed up to receive JCRC emails, you can do that on our homepage at jcouncil.org. I want to thank all of our co-sponsors again: Federation, AJC, AALJ, Tzedek DC, and I wish everyone a wonderful afternoon. And Helene, thank you again.
Thanks for having me.